Welcome to our YouTube video series exploring the legalities and realities of independent contractors versus employees. My name is Christopher Neufeld, the Neufeld Legal. And in this particular video, we're going to be discussing senior personnel who are put in the position of independent contractors. And what we're focusing on is individuals who are in senior management and other senior roles that are integral to the operations of the companies and have been engaged, not employed, but engaged as independent contractors to fulfill that role. Why this happens, why you should consider the legal ramifications of this and position yourself appropriately moving forward. So what tends to be a trend right now is a lot of these larger companies taking on more senior personnel to work as an integral part of the company and not hiring them anymore as employees of the company, but instead hire them as independent contractors. Even though those individuals in years past would have been hired as employees, given the fact that they are a component part of the business, integral to the business, reporting to somebody above, managing people below, and not really operating in an independent contractor fashion. So they are not independent of the business. They don't set their own schedules and the like. And why is that the case? Well, it's because of financial expedience, financial benefits that are incurred by the company that's hiring them, that they have chosen not to retain those individuals as employees. Because if those individuals do not at any time, especially at the end of their engagement, challenge their position with respect to being an independent contractor, the company is in a far better financial position in many respects because they're paying them straight off the top. And at the time of their disengagement, as you would want to call it, for lack of a better word, they are not obliging themselves to pay termination and severance pay. And this is a major economic benefit because the senior personnel, especially at the end of the engagement, if they were properly classified as employees, because they meet the classic definition, the legal definition of employment, could very well be entitled to anywhere between 12 and 24 months of termination and severance pay given their senior role. And this is a considerable amount of money for these companies to fork over, oftentimes in the hundreds of thousands of dollars. Nevertheless, what they've done with their legal teams and their structuring, their executives, is to instead engage these individuals as independent contractors as opposed to employees. And they've sought to frame the arrangement as one of independent contractor, even though clearly on almost every test that's out there, these individuals are in fact engaged as employees. They're integral to the business. They're reporting to someone above, and they're actually not having people below them who are their own people, their own employees, their own contractors, but instead they are overseeing operations and individuals who are engaged by the company that is engaging themselves. And as such, once you take a look at that test, you take a look at the other tests, that the controls are there, the tools are there, the lack of risk is with the individual, the lack of profitability formally is not necessarily with the individual, it's with the company. It is a classic employee scenario, and it should be treated as such. Nevertheless, given the inequities in bargaining power from the outside of the arrangement, where the senior personnel wants to take on the role, wants to have a position that pays them remuneration, they will assume the position as an independent contractor because it's not being offered up as an employee position. They don't want to offer that position as an employee position. They don't want to be putting them into their pension plan, their matching RSP plan. They don't want to be paying all the benefits, all the government contributions that would otherwise be paid to those individuals, especially since their senior level is such that it would be extremely costly. And a lot of these senior personnel don't fully realize that, or because they want to have the position, they have to accept that reality. And it's a reality that's designed and emanates from the inequity in the bargaining position when they come to the table. Because when you're looking for this new position, people aren't able to say, well, technically, legally, the position is one of an employee as opposed to that of an independent contractor. And as such, you should be treating me as such. It's unfortunate, but you're not going to get the position necessarily if you have that. Right away, you're creating tension, conflict, and problems with the company. So that's a no-go. On top of the fact that a lot of people don't even realize this until later on, until they come to the point when they've been working for a considerable amount of time and they're on the verge of having to either renew their contract, as they say, even though it's an employment relationship, or they have been removed from the position, which is effectively a termination position. But they take on the role and they have to effectively just continue to proceed with that role going forward. And they really don't have much in the way of challenging the situation, even during the course of their engagement. Because still, the company, which is the de facto employer of them, holds all the power and all the strings. They have considerable money behind them. They have considerable leverage, and they have considerable concern about making this a trend. So what do? They continue to exert their power, whereas the senior personnel is pretty much finding themselves having to continue in their role, accepting the position they're in, because to do otherwise is to jeopardize their engagement with that particular company. And especially if it's paying well, they don't want to jeopardize their position on this matter, especially at this time. So what happens is during the course of their engagement, they are in a very difficult and challenging position with respect to trying to position themselves to become an employee. And it is even when these contracts get renewed, the contracts, because of their quasi-renewal terms, which, given the fact that this is really an employment relationship as opposed to an independent contractor relationship, should not really exist, is nevertheless leveraged by the company to exert control over the finances and the operations of the senior personnel. So the only time that there really is an ability to pursue this, although what should be done is you should be accumulating information, maintaining solid records as you go through, is when the engagement is brought to an end. Because it's at that time that you have the ability to challenge what has been transpiring for oftentimes years. Because what happens is the company then asserts contract's over, or here's a contractual arrangement as to what's allowed to yourself, and there's nothing more. When in fact, you should be entitled to termination pay in lieu of notice. You should be entitled to severance pay in these circumstances, because the arrangement was one of employer-employee versus company independent contractor. But All too often, people don't recognize this, don't challenge it, don't bring it to the fore. And what you should be doing is, if you're still engaged with the company as an independent contractor, you got to be making meticulous records. You got to be getting information about how your role is with them, and look to other videos and other information as to what you should be doing. But when you're effectively discontinued, especially when you're discontinued without really any cause, and they look to the contract and say, well, company is going to give you 1 week's notice or 2 weeks notice, even after all these years of working there, that is when you have to look into it from a legal standpoint. You have to engage with legal counsel to understand where you stand and what your rights are relative to your being brought away from this position, which was that of senior personnel, a senior manager oftentimes, who was effectively an employee, although hold the title of independent contractor, for what all that says. You don't really have independent contractors who are integral to the company, who are senior management to a company, that are independent contractors. No, they are employees. And when you're taken out of the position, that is when you need to challenge the situation, because given both the Canadian and the American approach to who are independent contractors versus who are employees, if you're senior personnel, if you're in senior position within the company, even though you are given the title of independent contractor and the arrangement is such, this was an arrangement that was designed to benefit the company. It was not designed to benefit you. They might have given you a bit of a story as to why it's of benefit to yourself. The only reason it benefited yourself was that you got the position. But the company, more likely than not, fully knew that the arrangement was one of employer-employee. Naturally, so there are arrangements where you are truly an independent contractor. In those situations, you have to get clarified with a lawyer. But then again, you might have been a dependent contractor. But what is a dependent contractor? You're dependent upon one source of revenue for the entirety of your time there. You're reporting to people. A dependent contractor is really nothing more than an employee, but for the arrangement that is effectively forced upon you by the company, let's call it. Once again, because the company is making determinations that are in their best financial interest. And they are not providing you with the requisite common law and statutory requirements that would otherwise be afforded to yourself, because they're hoping you're never going to challenge them, that you're happy with the job and you're happy with the position and the money that you're getting paid. But at the same time, what they're looking at doing is saving hundreds of thousands of dollars by simply classifying you as an independent contractor and hoping that you do not challenge it. So if you find yourself in that kind of position and your senior personnel have considerable seniority, what you need to be doing, whether it's you're hiring in that position as an independent contractor, where you're working that position, during that time frame until you are no longer with the company, what you have to be doing is making sure you maintain meticulous records and you engage with legal counsel to understand what you need to be doing going forward. So you position yourself properly and you're prepared for that final day when you're no longer with the company. And how do you deal with it? And how do you ensure that you get all that you're entitled to? Because you are, in effect, an employee. But you have to make sure that you're an employee as opposed to an independent contractor. Because there are circumstances, yes, where you could very well be an independent contractor and this would not apply to yourself. But if you're not, what you need to do is be preparing in advance. And when you are no longer with the company and you've got your notice, and according to the contract, you're now pretty much out on your own, that is when you need to be engaging with knowledgeable legal counsel who is admitted to practice in the jurisdiction within which you are working. And you have to go through all those materials you've collected, all the information you retained, and figure out how best to approach your situation. Because the last thing you want to do is be leaving considerable amounts of money that you have effectively earned or you are otherwise legally entitled to and collecting upon them. Simply because the company decides to play games with respect to how you're titled, how your contract is formed, that was always within their power. And they knew better than to do that. They knew full well what the arrangement is from a legal standpoint. It's very clear as to who should be an independent contractor, who should be an employee. And most senior personnel, if you're integral to the business, if you're reporting to somebody and you're reporting down and you're not operating for different parties and the like, you're clearly not a independent contractor. And yes, there's a legal test, and then yes, the company is going to challenge it. But at the end of the day, you have to look at it and see if it's worthwhile pursuing. Because as I say, there is potentially hundreds of thousands of dollars that's going to be left on the table if you don't properly pursue these matters. Because we're talking about trying to avoid what the statutory requirements are, what the common law requirements are as to how you take care and treat employees. And that should have been given to yourself and is not being provided to you because simply you were told to sign a piece of paper at the outset that the employer, the company, knew was not appropriate for the position, and they continue to push it on and try to save considerable amounts of money from it. So that's what you have to be looking at and why you should be engaging with legal counsel at that point in time to ascertain if there is a course of action for yourself, which there very well may be. Thank you.